What Social Security is not going to tell you about applying for disability. Hi, my name is Wendy, and I worked as a Social Security disability examiner for 5 years, and I made decisions on Social Security disability claims as an initial examiner. After that, I worked for attorneys for about 20 years as a paralegal, assisting people who had applied for disability, ones who had been denied. I filed appeals, I prepared files for hearings, and got information from clients to help them to get ready for their hearings. There's a lot of information Social Security is not going to tell you. So let me start at the beginning. First of all, when you file an application, you can do it online or you can do a paper application. You can make an appointment to go in the office to do it. I recommend doing it yourself. That way you can take the time to fill out the application appropriately. I recommend doing it online. I know it sounds scary, but you can just go to ssa.gov and put in that you want to apply for Social Security disability. This is the type of disability where you've worked and they've taken wages out for Social Security. You can also apply for SSI, which is a need-based program, and you don't have to have worked in order to apply for SSI, but they do look at your household income, they do look at your assets. You can only own a certain amount of items worth a certain amount of money, and you can only have a certain amount of money in your account. I believe it's around $2,000. Now, as far as the application itself, make sure you fill it out completely. That was the number one problem I had with disability applications when I was an examiner and when I worked as a paralegal. I would look at the applications and they weren't completed. They weren't filled out completely. One of the things on there that they don't tell you that it is extremely important is where it asks you, what is the date you became disabled? This is the date Social Security is going to look at as far as determining that you became disabled or not. So if you give them today's date, they're not going to find you disabled as of yesterday or last month or last year. They literally are going to start with that date. So if you stopped working, let's just say a year ago, use the date you stopped working as the date you became disabled, assuming that applies. I'm assuming you stopped working because of your disability. Obviously, it's different for everyone. If you have an attorney, you can ask them about that. I'm not giving legal advice. This is just for educational purposes based on my experience as a paralegal and a disability examiner. I am not an attorney. I'm just giving you advice as I would with my clients when I was working for the attorneys and even when I worked as an examiner. So pay attention to that date because that date is important. People would complain, oh, they didn't find me disabled until such date. Well, if that's the date you put on your application, that's the date they're going to look at. So it doesn't look important on the application, but it is very, very important. Second, make sure you list all of your conditions on the application, everything, even if the condition doesn't make you disabled. So for example, let's say you have arthritis, diabetes, you've had a history of back surgery, you have problems with your vision, problems with your hearing, any of those things, just list them all. High blood pressure, even though one condition most of the time is not going to get you approved, there are exceptions, obviously, if you're blind, if you're completely deaf, those kind of things, obviously. Make sure you list your history too. If you've had surgeries, you can list those things on there as well, especially if you're having complications. Let's say you had back surgery and now you have back problems. So you want to list those because they have to investigate every condition you list. So if you only put one on the application, that's all they're going to look for. And that's what they told us as disability examiners. So even if it doesn't seem important, list it on the application because Social Security has to investigate it if you list it on the application, or at least that's how they're supposed to do it. Whether or not they actually do, it depends on the examiner and who's processing the case. But when I was an examiner, that was what they told us. We had to investigate everything. That being said, if you have any mental conditions, even if you don't think they're severe, depression, anxiety, anything like that, list that as well, because again, they're going to have to investigate it, and it goes towards affecting your ability to work. If you have anxiety attacks being around a lot of people, that's obviously going to affect your ability to work. If you leave that off the application, they might say you can do a job working with the public, and maybe you can't because you're have an anxiety attack when you see people, or you freeze up. Make sure you list all of your doctors. I usually would tell people for the last 5 years. Again, it just depends on when things started. If you had a car accident that started everything, then I would put the doctors from when you had the accident. Now, granted, if it was 30 years ago, those records may not exist. But if you were at a hospital, or you went to the hospital, or you had surgeries, at least list that information. If you have the records, that's great. I would supply those with the application, but please do not give them your originals. Give them copies. Keep a copy of everything you give to Social Security. They are infamous for losing things or claiming that they just never got them. And when I worked as a paralegal, I would send things return, receipt, certified mail, and they would sign for them, and then they would get on the phone with me and tell me that they didn't get it. And I had a signed receipt saying they did. So I'm telling you, keep copies of everything you send them. Now back to the doctors. So when you list your doctors, list everything. Doctor's name, name of the clinic where you saw them, the address, the phone number, the first date you saw them, the last date you saw them, and your next appointment if you have one. Put how often you see them. There's a blank in there where you can fill in how often you see the doctor. You know, I see this doctor every 3 months for follow-up. Make sure you put that in there. Put in there what conditions they see you for. That's important so the examiner knows what kind of records they're going to get from that particular doctor. Now, if you see a bunch of doctors at one place and you don't remember all the names, let's say, for example, the VA hospital, because they're infamous for changing doctors around. Don't worry so much about the doctor's name. Just say, I am seen at the VA clinic in such and such city, list the address, the phone number, and you can just say, see various doctors, because obviously all the records are going to be with the VA hospital. If you can get the records, that's even better. You can provide those. Again, keep copies. The VA, in my experience, when I worked in North Carolina, I'm assuming this is everywhere, but I don't know for sure. The records were not in chronological order, and they were done in a format where they were one large printout, so you literally couldn't separate them and put them in order because the visits would carry from one page to the next. That's just the way it is. It's okay. But if you do get records from a doctor, take the time to put them in order, because you would be amazed how doctors just throw their charts together and they don't put the records in order. And if they're not in order, Social Security has to take the time to do it. And that just gives them another reason to take their sweet time with your case. Take the time to put them in order, chronological order or reverse chronological order. Doesn't matter. Just in order by date, even including lab results, test results, put all that in there. The more information you give them, the better. Also, get a list of your prescriptions from your pharmacy. All you have to do is ask for a printout. It's free. They'll give it to you. They're going to ask for a list of your medications, your dosages, who prescribed them to you, things like that. You can put that on the application. I encourage you to do that, but you may want to also attach that list to the application because it will be 100% correct because it came from your pharmacy. And again, make sure you keep a copy of whatever you give them as far as that goes. They're also going to ask about your work history. There's not a lot of room on the application to put your work history, so try to condense it. For example, I worked as a paralegal for about 20 years doing Social Security disability. I also did a little bit of workers' comp. I did plaintiff and defense. So rather than listing out every single firm I worked at, I would just put paralegal, Social Security disability, 20 years, and then list the duties that I did. Make sure you include any physical and mental things that were required by the job. So for example, let's say you had to lift boxes of copy paper and carry them to the copier and load the copier. So then you had to bend and stoop to load paper into the copier. Or let's say it weighed 20 pounds. Put that in there. If the job was really stressful, you were dealing with clients calling constantly. Some of them were not happy. So that was a stressful situation. Put that on there, because again, Social Security is going to look at what you can do, what you can tolerate mentally and physically. And if the job you did requires things you can't do anymore, then they're going to go, okay, you can't do that job. Let's look at what other jobs you can do. So it doesn't seem important, but it is very important to list those. And chances are they're going to send you a work history report to complete. And again, when you get that, complete it, send it back. I would recommend keeping a copy, because they might lose it and you don't want to have to fill it out again. It's a real pain to fill those out. I have assisted clients with filling them out in the past. You just want to put as much information in there as possible. If you did the same kind of job, let's say you were a truck driver for 30 years. You drove an 18-wheeler for various companies. Just put it as one job. You don't need to list every single company. I mean, you could, but if the job was the same, for the most part, just list that job, 30 years, from whatever year to whatever year, 2020 to 2025, for example, and list what you had to do on that job, and really think about what the requirements were physically and how that compares to what you can and can't do now. Make sure if there's any other comments you want them to know about your condition, that you put those on there. For example, let's say you have to use a cane to get around. Put that in there. Say, I have to use a cane even in my house to go anywhere. When I go out to the store, I have to use the electric cart. If you have a disability plaque in your card or in your car from the DMV, then include in there that you have that and why you were given the placard, because that's relevant as well. Now, once you've done all of this and you submit Social Security, they should give you, as you're entering it online, they'll give you a re-entry number. Write that down, because if you stop the application or your computer crashes in the middle, if you don't have that re-entry number, you're not going to be able to finish your application. It's going to lock it out. It's going to lock you out, and then you're going to have to call Social Security and finish it. Once you're done, it will give you a receipt. Print the receipt and keep a copy. I would recommend going to Dollar Tree and just get you a little binder or some folders and just put all the paperwork in there. Everything you get from Social Security, everything you send to Social Security, or get an envelope. If you don't want to organize it, you just want to keep it together, put it in an envelope. Heck, put it in a plastic bag. Just keep it all together. I had clients that would bring me plastic bags full of information, and that was fine. I would separate out what I needed, what I didn't need, and it helped us to construct their file and know what to include on their application. So once you file the application, it goes to Social Security. Social Security is going to verify somewhat that the information is there. Half the time they don't really look at it. Then they're going to forward it to the Disability Determination Office in your state. I worked at the Disability Determination Office in Raleigh, North Carolina for 5 years. So we got claims for any person in North Carolina that applied. So we would then process the application. We would check to make sure it was complete. We would look to see what the doctors were and the conditions, and we would order the medical records. That was what we did. If the application was incomplete, then I had to call the person, chase them to get more information, delays processing. So just make sure it's complete. If you have records in there, that's great. They may still order more records. They'll probably send you a function report, and they'll ask you to fill it out and send it back. Make sure you do that. They may also send a function report to someone who knows you. Maybe you listed a neighbor, a friend, a spouse. They'll send them one to fill out. Make sure they fill it out. Now, the thing to keep in mind with that report is put on there what you can't do more than what you can do. That's very, very important. So let's say, for example, it says on there, what kind of household chores do you do, or do you do household chores? Now, if you say, I do the dishes, I do the laundry, I sweep the floor, and that's it, then they're going to go, oh, well, you said you have back pain, but it must not be that bad because you do the dishes, you sweep the floor, and you do the laundry. But in reality, it may be that you need help doing these things. When you do the dishes, you have to sit on a stool. You have to take breaks because your back hurts. It takes you all day to wash the dishes. Maybe when you do the laundry, you have to put it into a wagon and drag the wagon to the washing machine because you can't carry the laundry basket. Or you have a spouse that carries the laundry basket down the stairs or from the room to the washing machine, and they load the washer for you. Whatever the case may be. Make sure you put those things. If you talk about, oh, I cut my own grass, okay, they're going to assume you get on the lawnmower, you cut the grass. If you're using a push mower, especially, put that on there. If you cut the grass, but you have to do it in 15-minute increments because of back pain, for example, put that in there. If you cut the grass and then you have to spend 2 days in bed because your back hurts so bad, put that on there. Again, what you can't do and how when you can do something, it affects you. They're going to ask if you take care of children, if you take care of pets. And again, this is a trap in the sense that they're looking to prove that you can take care of pets and you can take care of children. So if you have help with these things, or you do them, but you don't do them in the traditional way. For example, you are able to feed the pet, but you have to use a grabber tool to pour their food or to grab their bowl, things like that. Make sure you put that in there. Of course, the work history, a lot of times they're going to send you that to fill out. Again, excuse me, fill that out completely. Mark how much stooping and kneeling and bending, because if you don't fill that out, they're going to probably ignore it, or they're going to have to call you to do it with you over the phone. And they have a lot of I had 400 cases when I was there. They don't have time to call everybody to go, you didn't fill out your form properly, so you're going to delay your case. And I know they're a pain to fill out. Just do the best you can. Fill in as much as you can. If you didn't have to do any stooping, put a 0 next to it. Don't leave it blank, because if you don't put anything there, they assume that you didn't complete it. And they used to tell us that all the time when I worked for the attorneys. If it's blank, then it's not complete. You have to put a number there, even if it's 0. And use the bottom part where you can put the description. Put in as much information as you can about the job. You can even go online and look up job descriptions if you want to help you, or use ChatGPT to help you write a description of the job that you did. They're mainly going to look at the last 5 years of your work history. If you have a mental impairment, meaning depression, anxiety, they're going to want to know, are you on medication for that? If so, who prescribes it? Does it help? Yes or no. Have you been hospitalized for it? If you've been hospitalized for a mental impairment, I know it's embarrassing, but it actually helps your case. So make sure you put down when you were hospitalized for your mental condition. If it makes you suicidal, make sure you list that. I hope it doesn't, but list that as well. If it's caused you to become a recluse, or you have a temper with other people, put those things on there, because that's all going to be applicable to your case. Now, if you get denied, you have 60 days to appeal from the date of the letter. Generally, they'll give you about a 5-day leeway for mailing, but really 60 days. So when you get that letter, it'll usually say notice of reconsideration, if it's a reconsideration. Trying to remember, it's been a little while since I've done these. You'll have a decision notice for your initial claim. It'll have a date on it. It'll usually say something like, we have found you to be not disabled because we believe you can do your past work of blah, blah, blah. Or you may not be able to do your past work, but we believe you can do other work. Or the kiss of death, we have not found your conditions are not disabling. And basically they're saying they're non-severe. And non-severe is really bad, because they're saying you really don't have that much wrong with you. We're not even going to look at your past work. We think you can work because you just don't have anything wrong with you. So that's one you definitely don't want to see, which again goes back to having a complete application. So you can file the appeal online. You can fill out a paper appeal. Again, same rules. Anything you send in, make sure you keep a copy. If you do it online, keep the receipt. If you get denied at the reconsideration level, that's the second level, then you have to file requests for hearing. Pretty similar to the first two steps. You can do it online. Make sure you follow all the rules I gave you for the first two. The thing to remember with the appeals, reconsideration, and request for hearing, you need to put something new in there. Because if you put the exact same information, they're going to give you the exact same decision. Literally. They'll say, oh, well, you have no new treatment, no new conditions, nothing has changed, therefore we are affirming the first denial. And they'll do it pretty quickly. If you get a decision pretty fast, then that's what happened. So even if you have to just say things have gotten worse, obviously we want you to be honest. Don't lie. That's very important. I'm not telling you to lie. I just telling you to focus on new information. Give them a new doctor's appointment. You're going back to see your doctor in a month. Maybe you have a new doctor. Maybe you've been to the emergency room. Those things are important. When it comes to medical treatment, any medical treatment is relevant. Hospital visits, urgent care visits, primary care, OBGYN visits, your urologist, whoever it is you see, those visits need to be included in there. And if you have any new conditions or new medications, list those as well. Now, at the hearing level, it's going to go to the hearing office, and they're going to have to assign it to a judge, and they're going to have to schedule a hearing date. And it's different in every state. Excuse me. When I did it, initially it took 18 months to get a hearing from the date you filed the application. It's gotten better because with COVID, now they're doing video hearings, phone hearings, or in person. And you get to pick which one you want. The judges, I think, I mean, it varies. Obviously, every judge has their own preference, but a lot of them do like the video hearings. Phone hearings are kind of a close second. You can do that. That way you don't have to leave your house. You don't have to worry about getting lost on the way of the hearing or having a problem with getting in the building or finding a ride, or if the weather's bad. I saw a lot of hearings get canceled in North Carolina because of snow and ice. If you have a phone hearing, doesn't matter what the weather is, they can do the hearing. In fact, if you go on vacation and your hearing is set, you can do it by phone from wherever you are. So that's kind of a plus. I know people like for the judges to see them, but if the records are there, a lot of times that it doesn't make as much difference as you might think. I mean, obviously, if they can see you, that's helpful if you have a visible disability. Keep in mind, complications from disabilities are what they're going to focus on. The things that functionally affect you. It's not your diagnosis. For example, I'm a type 1 diabetic. That doesn't make me disabled. Now, let's say I had an amputation. I don't, but let's say my leg was amputated because of diabetes, because, you know, I got neuropathy and then lost circulation in my leg, and then they had to amputate. Okay, that's important. List that. Do you have a prosthesis? If you have a prosthesis, put that in there. If you can't wear a prosthesis because of infections on your stump, or they're not comfortable, or the shape of your stump won't allow it, put that on there. That's important. Those kind of things. Now, going to a hearing, a lot of people have different opinions on this, but I would say, yes, it's good to have an attorney, because a lot of the judges just don't have the patience of dealing with someone who's not represented, because you just don't know how to present your case. And judges like the cases wrapped up with a nice pretty bow. And that's what an attorney is going to do. They're going to send in a brief that basically summarizes your case and why you should be found disabled. And I used to write those for attorneys. And there's a lot of things in there that you're not going to know to include. And it's going to talk about all the other things that I mentioned. It's going to give a history of your medical treatment. It's going to talk about your medications, your side effects, your work history. And they're going to look at the rules of Social Security and show why you meet those rules or equal or your medical vocational approval. Your education level is going to come into play too, so make sure that you have that clearly listed. If you are one of those folks that unfortunately is illiterate, I know it's embarrassing, but put that on there. That will actually help you, because a lot of jobs require reading. So if you can't physically do what you used to do, they're going to want to put you in an office job. And if you can't read or write, I don't know how you're going to do an office job, because you're going to need to take notes. You're going to need to use a computer, things like that. We see that a lot with, for example, folks that have driven trucks. We've had guys, including my father-in-law, who's now passed away. He had a third grade education, couldn't read or write, but he ran heavy equipment for, I don't know, 35 years, something like that, until he couldn't do it anymore. So those are things to remember. Now, once your case has been presented to the judge, you've got your hearing has happened. The judge is not, most of the time, they're not going to do a bench decision where they make a decision on the spot. Sometimes they do. It does happen. But a lot of times you're just going to have to wait. Is there a time frame? No. Social Security has no time frame on any of the levels. They can take as long as they want to make a decision on your case. So don't expect it to be in 2 weeks or 4 weeks or 3 months or 6 months. It might be a year or more before you hear something. It just depends. It depends on the judge, depends on the state, depends on the caseload. So it's really hard to say what your timeline is going to be. I think you can go online and look those up, use Google, and look up for your state if you want to see what the average wait time is. And I think they also have, for the judges themselves, what their average approval rating is for cases. So if you want to dig deep, you can look for that as well. Some judges are known for denying people, and attorneys are going to know which judges are easier than others and know you cannot pick your judge. But again, I really do think it's worth it to have an attorney at the hearing level. If I had to apply for disability, I would probably have an attorney, even with all the knowledge I have, because I know how much they can help make your case. They can submit records electronically to Social Security. They can verify those records are there. Now, if you don't have an attorney, they will send you a CD that has all of the records that Social Security has on it, and you can open it up and look at it. It's probably going to be a lot of paperwork, probably too much to print, which again is another reason to have an attorney. Now, if you get denied by the judge, you can appeal to the appeals council. Again, you got 60 days from the date of the judge's decision to do this. If that gets denied, which honestly, my experience, the appeals council denies almost everybody. I very rarely saw them approve anyone. Most of the time they would remand it back to the original judge for another hearing, which is kind of annoying, because if you've already been denied by that judge, you don't really want to go in front of them again. But the appeals council can say, yes, I want this judge to hear some more evidence and make another decision. It won't take as long, because they then have to do the hearing and then send it back to the appeals council. That gets denied, then you are going to request for a federal appeal. Now, I've never done those, so I can't really speak much about them. There are some attorneys that will help with that. I definitely would recommend getting an attorney at that level. There's obviously a lot more to this, but this is kind of a summary video of the whole process of Social Security disability. I'm going to be doing more videos to answer questions. Please like, share, follow. You can also go to my TikTok channel, which is also Diabetic Mom 72. I have a lot of videos on there, short videos about Social Security disability. I also have just gotten a diabetic alert dog as of December of 2025, who is training to alert me to high and low blood sugars, because I am hypo-unaware, meaning I don't feel my lows, and I have blacked out from those. So that's scary. So there's going to be some information on him on my other channel as well, and I am open to suggestions for other videos about Social Security, questions that you have, things of that nature. And I appreciate you sticking with me for the whole 30 minutes. I know this is a long video, but thank you for watching, and I hope you'll come back again and check out my other videos. Thanks. Have a great day. Bye.